of the respondent father will be in touch with his daughter and can be kept intact by imposing certain conditions. Petitioner specifically filed an affidavit. Lordship, next page, para 17, petitioner wife has filed an undertaking. All of this, Your Lordship, which has been given. Page 38, Your Lordship. Last paragraph, paragraph 34. With the aforesaid direction and noticing that the impugned order has failed to consider the important aspect of the right to development being vested in petitioner and she cannot be asked to choose between a child and career, impugned order is set aside. The next judgment, Your Lordship, from page 40 onwards.
43.
43, Your Lordship. There are several other relevant portions, but I'll just restrict us itself to para 18, page 43. Now coming to the question of the child being taken. This, Your Lordship, this is the extract. This is the portion which I read in the other judgment. This is that Vikram Veer Vora's judgment, Your Lordship.
Yes.
And the last of it, Your Lordship, appeal is dismissed, direction, respondent mother file an undertaking to the satisfaction of the court.
This one is Vikram Veer Vora.
Your Lordship, at page 57. Your Lordship, at page 57.
Yes. Page 60.
Page 60, Your Lordship. 60, para 16.
Fourth line. Yes.
The third line onwards, the appellant is gainfully employed in Singapore and her desire that she should be allowed to take the child with her is not artifice. The appellant, as a mother of the child, has been continuously with the child since birth, despite the demands of her employment. At page 61. Your Lordship, at this point of time, they have lived in the US, both of them together. They have lived in Pune. They have lived in Bangalore. They have lived also, when he didn't have a job, he lived with her parents for quite some time and did offline work, Your Lordship. This was in Chandigarh, Your Lordship. So his work, he can easily even shift to Bombay. Your Lordship, I'm even stating that he can even co-parent with her. He can take up an apartment very close to hers, or he can have weekends if he wishes to come by. And of course, on any of the holidays, he could even spend some time. She has absolutely no objection because she is herself voluntary, given the child to him at all points of time.
Yes. Also say that the mother has to go where the mother has gone.
And even with the judgments where she shifts from India outside, the father's asked to go and meet the child wherever the child is. But here we are all right with both of us.
Page.
And what a very serious violation of the lordship order, which the respondent is glossing over. That needs to be answered first. The majesty of this court is put into question.
Was there any interim order passed?
By your lordship.
No. Prior to the order came to be passed by me only with regard to not to take the child out of the
She
jurisdiction.
has gone without done it thereafter.
Your Lordship, we will file an affidavit even now. This is unfair. This is not correct.
Page 17, existing law arrangement. The second email wrote the middle of the page, Saturday, 1st March 1932. So she asked me to please go out and what she wants. I know this must be a mistake that if I call 3 times a day and ask for the keys to a Goa house, pick up Aranya this morning, can you please ensure you bring them in to drop her off tonight? Not as of 1st of March, the regular will exist in the morning, dropping her off in the evening. Therefore, my letter said relying upon messages between the parties of July 2024, October 2024, November 2024, where she alleges that I am suffering from addiction, that I have of various issues. It did not come in the way of my meeting my child. Admittedly, the mother had no objection. Mother was willingly sending the child to me, to my parents' house. So therefore, those messages and emails to the university and my submission will have to be ignored because the mother does not rely on that and denies other invitation on 22nd of March.
No, even she now also does not.
The offer is sent to her. I communicate the order to her on 22nd evening. The employment offer is sent to her on email at 9:21 p.m. on a Sunday, 23rd. So they put this was some. On a Sunday, 23rd of March, it sends an email, offer letter on an email. No other conditions. 40,000 rupees a month. Without the respondent to the person who was working in the US, we were both living in the US. $10,000 per month of salary. From 2018, she has not worked a single day. So the time we have got married. But for her to ask an offer of 40,000 rupees a month in Bombay, when she says that it is actually not fine for your hardship, she says 40,000 rupees I can manage living in a separate accommodation and managing my and my daughter's expenses. She says her father cannot hear 70% hearing disability. He is losing his eyesight. You can appreciate it. This is the event management company that conducts events late in the night or weekends, weekdays, every other day. The hardship is ultimately extended to what fact? Parents may face restriction. Whether it's in the child's interest or the what is to be seen. My humble submission is the move to Bombay was looking to alienate me and my parents from the child. It is as simple as from the child. It is as simple as that. There is no other reason for her to get an offer on a Sunday night, one day after the order is passed by this court, is said because of moving out. Can we say all the application for visitation filed today? Much before 40,000 rupees is the offer that she got for employment. Can we see her even at the 11th of March, along with that, if you decide to move to a smaller apartment, I'm open to discussing a fair contribution towards that rent as well. As I have already expressed, since I have no right to your house since I was evicted, I do not wish to be part of the lease anymore. Since the new agreement will be in your name and have sufficient savings, I expect you to handle the account independently. School fee. I have continued to pay Arania's school fees per month and I have already covered the term fees for 2026 academic year. Living expenses. As mentioned earlier, I transferred a substantial amount in November 2024 to cover support and your living expenses. I will continue to contribute a reasonable amount towards essential costs such as food, utilities, doctor visits, and other necessities, subject to a formal discussion which I am open to having whenever you are ready. Personal expenses. Since you have adequate funds available, I expect you to manage your personal expenses independently and do not furnish family payments. As I have mentioned multiple times to you, I am open to discussing and agreeing on a fair monthly amount for these ongoing expenses. However, if we have not been able to have this discussion and you have declined deviation, I will start transferring 50,000 per month from April 2025 to cover essential expenses until we reach a formal agreement. This contribution is contingent on my visitation rights remaining unchanged and my continued employment. Visitation arrangements. As per the agreement, the visitation rights are as follows. Weekdays, Saturday and Sunday, 10 a.m. to 7 p.m. Weekdays, I would like to see my daughter twice a week as I was doing until you permitted this. I assure you that I will respect your boundaries twice a week as I was doing until you permitted this. I assure you that I will respect your boundaries and not interfere in your personal space. Move after the lordship's order and get an offer of employment a day after it passed on a Sunday night.
What happened to our accommodation now?
I don't know from 23rd March, 8 o'clock in the morning, last the apartment. Today, I don't know where she is. I've had no access to my child, nor have I even spoken to the respondent despite multiple emails. Not all those emails I have produced from page number 11 onwards. Every single day, my daughter is writing emails to her. Her father writes back to me and says, the daughter and mother are unwell for 2 days. After 2 days, they will get in touch with you. That was on 24th of March. Today, we are on the 8th of April, 2 weeks later. Absolutely radio silence on that day. And all the letters of the resolution that we put to her are cases where the women were employed and they found better employment opportunities abroad. Court said, I will not allow a mother to choose between a career and a child. If she brings a better employment opportunity outside India, the child will go to the mother will be going to travel. That is not the case here. And can we see the technology of the Supreme Court in Oxford Sharma's case? Section 26 of the Guardian Wards Act. Once the court assumes jurisdiction under Section 9 of the Guardian Wards Act, the child stops being the Guardian Wards Act. The child stops being the ward of the parents and becomes the ward of the court. Therefore, any parent who wants to remove the child from the jurisdiction of the court, even temporarily, must obtain the court's permission before doing it. Sorry, there's one other document I wish to bring your attention. Page number 26.
Of your writ petition.
Application for writ. With the subsequent event,
37.
37.
Yes.
But 2025 at 9:25 a.m., 8 days after your lordship passes the order. But this is a question the respondent has to answer before the court. Because the Honorable Supreme Court says, section 26 of the Guardian of Contract.
Section
26 of the Guardian of Contract.
Yes.
A guardian of the person appointed or declared by the court, unless he is the director or the guardian declared by the court, unless he is the director or the guardian appointed by the other instrument, shall not, without the leave of the court by which he was appointed or declared, remove the wards from the limits of the jurisdiction except for such purposes as refuse time. Because section speaks of a guardian appointed by the court. In a matter that came to the Honorable Supreme Court, custody proceedings were going on between the father and mother. The father would move the child during the pendency of the proceedings from Goa to Bombay. Now, this is what the Supreme Court has observed about his conduct of Section Arunchal.
Yes.
Section
Yes.
Section 26, the special significance in that it casts an omnibus embargo even on the guardian of a person appointed or declared by the court from removing the wards to the limits of jurisdiction. This is because when a dispute arises between the parents and the minor, the court steps in as parents pay and accordingly appropriates or confiscates and the Lord has fabricated that offer letter of 23rd March only to circumvent or try to explain or justify contumacious conduct.
Yes.
Therefore, my humble submission, the application filed for modification was rejected, and my application for visitation kindly be considered because I have not had any access to my child in the last 2 weeks. More than 2 weeks.
Yes.
The very quick response, Your Lordship. As Your Lordship pointed out, that's a 23rd March, but it seems to speak about probably he's able to travel into future quite well. 23rd March is the message between his mother and he, but they seem to speak about a car that is traveling the Nelmangla toll on 30th. Nevertheless, as I had already mentioned to Your Lordship, not just the car, all her belongings, everything has been already sent to Bombay. Now they also say that he has not seen the child at all. Your Lordship may kindly recollect the moment we had this order, I personally had come before Your Lordship mentioning, requesting for 2:30. That is when we were supposed to sit down and try to see if they could reconcile. Conveniently, the council says, I'm out of town for the next 4 days, I'm going to Kabini. Even if he's going to Kabini, the parties could have spoken, but he said, I will come back and then I will talk. Tuesday morning, council again speaks to him stating, that's how the client informs. So they have made absolutely no effort. Obviously, the child would have been with him, been with the mother. All of them would have sat down and spoken. She had absolutely no intention to leave and go. She's been trying to make it all work. All the emails and the correspondence with her mother-in-law, with her sister-in-law, with him. She says, we've been talking about reconciliation and I'm shocked that you want to leave. And he's left the matrimonial home in November and left. October, he decided he left in November. He would come and go. She kept sending the child to them. This is how they were working it out. It's only when he's asked her to vacate that premises or says that you take up something else, she has nowhere else to go. That's when she takes up another. With respect to leaving the premises of this this honorable court, she has never violated. She's never stepped out. Her parents have come down here with one bag the day they came to know what he did, and they have not left after that. All the things have been shifted. That is all, Your Lordship. And with respect to the judgments that he's talking about, that was a matter that was pending before the honorable court and it was still being decided. At that point of time, that's what the father did. At this point of time, how will 26 even come into force? Because I have not even violated any order. I'm very much before this honorable court, moving this honorable court over 10 days ago, seeking 2:30 mentioning, and yet they have constantly been adjourning. And I would insist that Your Lordship conducts a probe as to how the file went missing, so that 3 of my memos that have moved for an early hearing have conveniently gone missing. 2 memos is retained before the registrar. Finally, when Your Lordship takes it seriously, the the file resurfaces. Therefore, it's not us who have tried to protract. It is they who have tried to see that this matter goes beyond vacation, wherein she is stuck over here. We've been absolutely forthright. We will even file affidavits to the effect about her job. And he says that Sunday they issued a letter. He's in his very own words. He said it's an event managed company which runs all kinds of events. These people work 24/7, and yes, she is taking up a pay cut because she has not worked ever since they got married. So she is going to get a better job once she starts working. But now to say this is not a good enough job, I am going to throw money at you. You come back. That doesn't work, Your Lordship. She pleaded with him. She said, "Let us work together." He refused, and now when she decides to take up a job, now he wants to come scampering. Even now, Your Lordship, any condition may be imposed, any amount of visitation for the father, we have no objection, Your Lordship.
Who's staying with you? No, you're staying with whom? At Bangalore.
Incapable to be alone, Your Lordship, based on all his addictions.
I'm sorry, no. I'm sorry, I forgot to use my decision.
40.
There is clear allegations that the petitioner has been responsible for the matter not getting this. I think that's true below the belt to respond.
Yes.
I get that pass. Page 41. This is a message sent by the respondent to my father. Uncle, I haven't had a chance to tell you this in person, so I'm sorry to say it over message. Adhinas and I are separating. He isn't happy in our marriage and wants to Karanya. Despite that, I want you to know that I would love for you to be as involved as you would like. Karanya's right to hear he loves you. Acknowledgement by the mother.
I'm grateful.
And she asked me to go over.
No. I had requested him to move out over Diwali. Your Lordship, I like the twist to it. October he moves out. She's pleaded with him, stay at least till Diwali and then go. I like the twist to what she's saying is, I had requested him to move out over this Diwali break to make the transition a little easier. So she's told him, hold on. During the break, slowly move out so that the child is not affected. She has not asked him to move out. This is a convenient interpretation.
All right, now what is the difficulty for you? You are allowed to go. Nobody's restrained you.
Please, Your Lordship.
You are allowed to go.
No, Your Lordship, without the child.
I have not restrained the respondent to move out of the jurisdiction of the family court.
True, Your
Only the
Lordship.
child to be not taken out.
Correct, Your Lordship.
Leave the child with him.
Your Lordship, not with an abuser.
No, his
Your
parents
Lordship, not with an abuser.
No, his parents
Your
are
Lordship,
there.
there's proof of weed. He's himself admitted to his addiction, and Your Lordship wants me to leave a 2.5-year-old child in the custody of a man who is into weed, alcohol, smoking, all of it put together, and his parents are not too happy. It's a daughter. They never wanted this child in the first place. He's produced some beautiful photographs which all of us can produce. Your Lordship, at this point of time, I would just seek Your Lordship passes an order. Where, as a natural guardian, am I allowed to leave the court from Bangalore? Am I allowed to come back for all the hearing dates? Or would I be restricted? I will leave it to Your Lordship. But the question of handing over is ruled out, Your Lordship.
We will consider it tomorrow.
Please.
I'll go and take up your job. No, there is no restraint. I'll go and take up your job. No, there is no restraint order against you. It is only for the child. The child shall not be taken out of the jurisdiction of this court.
We are aware of that, Your Lordship.
Yes.
We are aware of that. And Your Lordship, I would insist that an inquiry is also there with respect to.
You cannot insist, you can request.
Then I will request, Your Lordship.
Yes.
My insisting will probably be with the registrar. Here I will make a request, Your Lordship.
Yes. Next. No, that will not be considered here. That you have already filed a petition before the family. You can make the application before the family court, which has the jurisdiction to deal with it. It will consider after giving opportunity to the other side, after hearing and pass orders. Yes. There is Manjula, madam. No representation in matters called. Call after 2 weeks. 40 times the control. 40 is the one which they have done. Deep and Manjula. They have already taken, I have tick marked. No, that is already adjourned. No, cancel that order. 16th April.
For the respondent lordship.
May not happen today. Order on the maintenance.
Usually they say compete with the party. Late years the father need to pay, they also need to pay educational expenses at a particular sum a month or the higher whichever one they pay. Thereafter, the child school has to be moved. The father took the application form, the admission form, submitted the formality, the child admitted to the school. Then they refused to pay the fees and I never agreed to this. And also enhancement of maintenance, the mother kept asking me, he refused to enhance the maintenance, therefore he was fighting for me. Family. So I guess I'm not conscious of this.
We'll have it on 16th or something. We'll try.
Much
Let's
Much
just matter on 16th due to paucity of time. Yes.
Order 10,000 towards interim maintenance and additional 10,000 towards education expenses. Custody of the child has been the petitioner husband. I raised an objection saying I am not obligated to pay education expenses of the wife. She claims to be studying MBA and incurring expenses of 1.6. Now, subsequent development is today an application is filed by the wife before the MC court. Seeking to strike off the defense. I made a submission and I filed an appeal challenging that order. Since the respondent, the petitioner there, it's a petition filed by the wife seeking for dissolution of marriage. The Learned Trial Court would say 10,000 towards educational expenses.
The next page. Yes, litigation expenses 10,000. Which page are you reading? Page 41 and 42, operative portion. Huh?
Page 40 page 16.
About fifth line in my opinion. In my opinion, 10,000 towards the educational expenses and another 10,000 towards the maintenance awarded monthly, definitely to be the end of justice. Further, the petitioner has also paid litigation expenses to the tune of 1 lakh. It is true that the petitioner is considering to meet litigation expenses, but that does not entitle us to claim exorbitant amount. In my opinion, if an amount of 10,000 is awarded as litigation expenses, the same satisfy the said need of the petitioner. Thus, the petitioner is entitled to rupees 15,000 as a maintenance, pending rupees 10,000 as litigation. That is what I said. You said the other way.